somebody can grab the, could you grab that back? Thank you. Excellent. Ready? Okay. I'll call the Subcommittee on Communications and Technology back to order. We're under our hearing on HJ Res 37, a resolution disapproving the rules submitted by the Federal Communications Commission with respect to regulating the Internet and broadband industry practices. We have a couple more members who have been here for the duration and want to ask some questions of our remaining panelists. I appreciate our panelists, by the way, for staying and continue to participate. And with that, I would recognize the gentleman from Georgia, Mr. Gingrey.
Mr. Chairman, I want to thank you, first of all, for calling today's actually second hearing on the FCC order on net neutrality. I know that my time is limited, so let me like to proceed with my questions to these industry stakeholders that are present today, and thank you also for your patience. Dr. Kovacs, before we broke for votes, the distinguished ranking member of the subcommittee had kind of questioned your economic logic in your testimony, but you really weren't given an opportunity to respond to that, and so I'm going to go to you first, and maybe you would want to expound on that and my own questions. Is there currently some sort of network neutrality crisis warranting government intervention, or do you think we are better off letting the technology and the relationships between and among broadband providers and web companies just continue to evolve?
Let me try and address those in a whole bunch of questions that came up earlier and went away, and I think one of the best ways to answer that question is to look at the last few years and say that both the vast investment in fiber, that is Fios, most of the wireless broadband investment has come since the triennial review and since the classification of broadband as an information service. So to me, it clearly shows that giving the companies flexibility to run their businesses the way they need to run them makes it a lot easier for them to raise capital. It's not clear to me that at this point there is any kind of crisis. Certainly the incidents that have come up that the ranking member referred to were dealt with one by one under the old regime.
Well, so if you'll let me comment, and I agree, I don't know that there's a crisis. Do you see any market power analysis in this FCC order demonstrating that there truly is an actual problem and it's not just some speculation that there could be some future harm?
The FCC looked at an enormous record, and I think we do have to give them credit for having looked at an enormous record in reaching their decision. Having said that, there's not anything like the kind of analysis that you would have, an HHI index, that kind of thing, that would be looking even at the transport layer, at the broadband access providers, and there's no recognition that wireless actually in some markets does serve, and for some market segments does serve as a competitor. So I would disagree pretty strenuously with Ms. Chasen's earlier repeated comments about the duopoly. And there's also no analysis at all of anything above the transport layer. So the kind of market power, if there is market power, that Google, for example,
permitting me to reclaim my time, and I thank you for your answer. I mean, it's certainly nothing that I would think rises to the level of what the President said in his executive order recently in regard to rulemaking and what standards need to be met in regard to cost-benefit analysis. Mr. DeReggi, the testimony delivered earlier, Ms. Chase, I'm sorry she had to leave, but she stated that eliminating the FCC's network neutrality rules will put future entrepreneurs and small businesses at a significant disadvantage. Based on your testimony, I can tell that you are in disagreement with that characterization. In fact, you go as far to say that the FCC order will, and I think I'll quote you, result in fewer jobs and indeed stifle innovation. So in addressing Mrs. Chase's testimony, can you describe why the FCC order will do just the opposite of what she characterized?
Let me share my hometown of Barnesville. 70 out of the 300 homes operate home-based businesses. That was made possible because of 3 megabit broadband shared by 50 homes, which we provided. Broadband provides jobs, not HD video. When Netflix started streaming across that network, it compromised the businesses in our town. I had no choice but to slow Netflix. That's it.
Well, has there been a lack of innovation in the absence of government regulation over the internet during the past decade?
Repeat the question.
Has there been a lack of innovation in the absence of government regulation over the internet during this past decade?
Absolutely not.
Is this a hammer looking for a nail?
Exactly.
Mr. Chairman, I realize my time's expired, and I'll yield back.
I appreciate the gentleman's participation. Now recognize the gentleman from Kentucky, Mr. Guthrie, for 5
Thank you,
minutes.
Mr. Chairman. Mr. Turner, Mr. Markey's questioning established that you're here on behalf of the consumer. Do you think that the web content should also be regulated, or do you think it's sufficient that just the internet providers are regulated?
Well, we come at this from a perspective of economics. I'm sure Dr. Greenstein can speak to this. There are tremendous fixed costs to providing broadband networks. There are very high switching costs for consumers in those markets. There is nothing preventing a consumer going one click away to another website. So I think they exist in different markets. That's not to say there isn't problems with market power in those markets, but I don't think that the FCC, in the context of its authority over communication by wire or radio, should really be the ones looking at that. But certainly we would welcome Congress.
So they shouldn't address that market power in that place, that one has more than the other?
Well, again, there potentially is market power in the search markets, but it's not the same from a consumer perspective in terms of switching costs, nor from the barriers to entry for other competitors to come in. If you have a good idea for a search algorithm, it's very easy for you to start a search engine today. It's not the same for someone to go build a network next to AT&T's.
Okay, thanks. And that gets and Mr. Cicconi or Dr. Kovacs, you said it was going to be more difficult for capital for people to enter the market because of this rule. Now, would that affect AT&T and Mr. Cicconi more, or would it affect Mr. DeReggi and his smaller business more?
It would affect smaller businesses more, obviously. And
obviously, I knew that too. I just wanted to get the answer.
No, but I also, if you'll allow me just to comment on switching costs, if it is that easy for anyone to enter the search business, why have companies like Microsoft, for example, not been able, or Yahoo, not been able to very effectively challenge Google?
Mm-hmm. That's a fair point. That's what I was getting at as well. Thank you so much. And then, Mr. Cicconi, I know Mr. Shimkus asked, we've used the word uncertainty, I don't know how many times here today. I still haven't figured out, in the marketplace, and you said this brought certainty to business. What in the marketplace was there uncertainty about? I know in general there's uncertainty in the marketplace, but what in the marketplace did this rule bring certainty to your business?
Well, I think Mr. Guthrie, the uncertainty that was roiling these markets was largely a result of the prospect of pretty heavy-handed regulation by the FCC to implement net neutrality. They had a notice of proposed rulemaking out there in the fall of 2009 that was very specific and very onerous, and that was followed by a proposal that was laid out in the spring of last year that was even more onerous and heavy-handed.
But there wasn't something in the marketplace they were trying to solve that's real, a real problem in the marketplace today they were trying to solve?
Well,
if you don't want to go there, that's okay. That's okay.
I think it is fair to say that the uncertainty that's been created over years of this debate, and I think we should stress that the debate over net neutrality and the authority the FCC should have in this area didn't just start in January of 2009. It's been going on for 5 or 6 years. It got worse in 2009 and 2010, but we do feel that this rule addresses much of the uncertainty that debate helped cause.
Unless the new FCC wants to go further, if it's not settled. Mr. Greenstein, you said, what was the number you said, 70 to 90 cents of every dollar? Is that the gross profit? Is
That's
what you were
gross
saying?
margin.
Gross profit in typical internet service providers, is that what you're saying?
Gross. So that doesn't account for...
I know, it's gross profit. Now, when you said that, Mr. DeReggi, you were shaking your head no. And why were you shaking your head no?
I just wish and dream that I could have those type of profit margins.
Well, gross profit. Is your gross profit not that high as well?
No, gross profit is not that high. That would barely, revenue barely covers the antenna co-location costs, let alone a profit. Maybe if we're lucky, we can get legal and pay permit fees. No, I don't think so. Some business models may have those costs, but all WIFs aren't uniform. There's different costs to provide service at different places in the country.
Thank you. And Mr. Greenstein, that number.
I mean, I just got this from UBS and from Craig Moffett at Bernstein. I mean, these are authorities in this. I'm just quoting somebody else.
Okay.
And I think it's largely for wireline ISPs, so that's quite different than his business.
Okay. I just want to establish that. And Ms. Kovacs, Dr. Kovacs, I'm sorry.
Not to get arcane, but he's talking about gross margin, which is when you've removed only some part of the network
Variable
cost,
costs,
and then there's a huge amount of other costs that has to be covered. So again, net income is in the 5 to 10% range,
So, yeah,
which is what goes back to the shareholders.
Net income's what you have to go to your investors with, isn't it?
That's what goes back to your investors, exactly.
I yield back.
Thank you, gentlemen's time has expired. To recognize the gentleman from California, Mr. Bilbray, for 5 minutes.
Thank you, Mr. Chairman. Mr. Turner, you indicated in your testimony that you really don't think the FCC has gone far enough on this, and I assume that means that you would prefer the FCC to have gone and reclassified into Title II.
Well, look, I recognize that net neutrality appears messy, and it's really because it's a Band-Aid to what the earlier FCC
Okay,
did
well,
to
I'm
the
just
Act.
wondering about this. I'm trying to find the line. Would, in your opinion, the Title II be a better option for us to be going down rather than stopping at this level?
You may not be aware, but much of the large business enterprise market for broadband is today regulated lightly under Title II. Mr. Cicconi's
my point is that you'd like to expand that and bring it into this field.
Well, I think by doing that, the WISPA Association, which Mr. DeReggi was a member of, they would actually probably prefer that because it takes away the regulation on the internet service provider layers and moves
So
it
your
down.
support for going to Title II is because the some in the business community would like that?
My support for Title II is because that's what Congress adopted in the 1996 Telecommunications Act. It's the law of the land.
Ooh, well, let me say something. Somebody who was on the committee at that time. That some of this is an interpretation. I got to say one thing. Let me just say one thing. I just think that I want to clarify something. There was a comment made earlier. Mr. Turner, have you ever run for elected office?
I have not, no.
You've never gotten a vote? Okay, Mr. Chairman, I just want to clarify. There's statements made here that Mr. Turner represents consumers. Now, people around the world are standing up and demanding the right to elect their representatives. And it's not just on Mr. Turner. We do this all the time. I'm sorry. In this country, you elect your representatives. And I really think it's quite inappropriate from this gentleman's point of view for us to be in this institution and basically assume that people represent someone without that person having the right to choose who represents them. Self-declared representatives is what Libya is fighting against right now. So I just want to say that in all fairness, nothing personal. It is something that we do in this institution that is quite inappropriate, I think, seeing the makeup of this institution. So
I meant no offense, sir. We do have 550,000 members that I do represent that are consumers.
Right, okay. And you can say that. But the fact is that when it comes down to it, the choices you make, we try to open them up. I just think that we got to remember that we elect people in our system, and that I just worry about how many people are identified as representatives without having gone through a due process that I would assume would be a minimum standard in our society. That aside, I wish Mrs. Chase was here because I had a question, but Mr. DeReggi, interesting thing of Mrs. Chase's situation, she was at Zipcar, and if I remember right, normally if she wanted to get basically rated somewhere on through the system, it would either be alphabetical, which would put her at the bottom, or it would be based on how many hits she gets. Now, if you're a little guy going up against a big guy, that system kind of puts you at a major disadvantage, wouldn't it?
It surely does.
Now, so she now actually, her company or former company, had the option of paying into an advertising mode that moved her up to the front and made it big. So by having the ability to sort of pay to play, that gave her the ability to compete on a much more even footing than somebody who was an established big guy, right?
That's correct.
Now, what would happen if the FCC said, no, that's not an option either, that somebody can't buy their way onto the front page by paying for advertisement? What would that do the little guy's ability to take on the big established operations in this kind of business that Zipcart was in?
Yeah, that would let the little guy have an equal opportunity.
Okay, I just think that as we go down here, there's we forget that a lot of times what we perceive to be a big advantage of the big guy is really the only vehicle that a little guy has to compete in the system. And I always get kind of frustrated if somebody comes from a blue-collar background, and that's why, Mr. Turner, I bring this up all the time, because everybody says they represent the poor and the working class, and some of us never got to elect these guys. But I think that when it comes down to the system of who gets to participate, the fact is big government favors big business. Little business is the one who keeps big business honest, and allowing the little guy to compete, get access, that's what keeps the big guy honest. Traditionally, when we think we're helping with big government, we end up actually creating more protection for the big guy.
Gentlemen,
is that
time.
Fair to say?
The concern for small businesses is why we are strong supporters of network neutrality, sir.
Thank you.
Gentleman's time has expired. Now recognize the gentleman from Illinois, Mr. Kinzinger, for 5 minutes.
Thank you, Mr. Chairman. Thank you for spending your morning, afternoon, and forever with us. I appreciate it. I've said this before. One of my concerns with this whole thing is, we can argue the merits for or against net neutrality, and, I have my position, but one of the biggest concerns is, and you 5 now, but 6 weren't necessarily privy to this discussion, but to me, it's just amazing, the whole idea that we're sitting here talking about something that I don't even think the FCC had a right really to do, that was outside of the venue, outside of the will of the body of the American people. I mean, last Congress, over 300 members of this body signed something opposing these rules. I heard the FCC commissioners talk about that they're pretty doggone sure, basically, that this is going to hold up in court. Yeah. Well, if you're not positive, why don't you come talk to us and we can talk about it. But, so that's, I think, with this whole discussion, again, talking about the merits, where it's good, where it's bad, the 10,000-foot overview concern I have is just the fact that we have regulatory bodies that are operating outside of the will of the House of Representatives, and that, to me, is unbelievable. That is not what was ever intended to happen. So I had to get that off my chest. Let me say to Dr. Kovacs, I hope I'm saying your name correctly. If the current order, I know you've discussed this, but I want to ask this in this way. If the current order from the FEC were to be implemented, with the current lack of complete definitions in a lot of areas, in many of these aspects, do you believe that that lack of definitions in this current order would create the necessary certainty that broadband internet access providers will need to determine that long-term strategy?
I think it's going to take a long time to get to the point where we know what the definitions are, because it's going to be case by case as protests are filed and the FCC deals with them. So we have quite a while to go before we have certainty about what the rules are actually going to be.
So we don't even know in 5, 10, whatever, I'm just pulling those numbers out. We don't even necessarily know what this is all going to look like anyway. So this is all still subject.
It's going to be a multi-year process.
Right. Mr. DeReggi, I hope I'm saying that right. You guys have difficult names. You need an easier one like Kinzinger. I currently represent a rural district. It's fairly rural, and it's served by a lot of small companies like your own. One of the things that I tend to note with consumers in these kinds of areas is that they choose, in many cases, small companies like yours so that they're able to pay for the services that they want to have in that area. The FCC order has a provision that mandates that every consumer be able to access every service on every device regardless of cost. Could you expound a bit on how that particular provision would impact your pricing plans, as well as what you think it would do to your ability to serve customers in areas like that?
Well, it would definitely force us to raise our prices in order to be able to do that. But it's also not physically capable of happening because the spectrum's not available to be able to fulfill that request.
So we're basically creating something, or something's being created that's just not even possible to follow through on anyway.
You're basically making me operate as a criminal because I can't comply.
Right, okay. And, finally, Mr. Turner, just to be clear, yes or no is fine on this, please, just yes or no. If the FCC loses in court, will you support Title II regulation of the Internet?
I support Title II regulation of Internet access, the transport segment of Internet access services today.
So the answer is yes.
The answer to,
okay.
You didn't ask the question the way I would answer, but yes, the answer on the connectivity side, not the access service side.
Okay.
Yes, sir.
So basically, a vote against this resolution is a vote for Title II regulation. I yield back. Thank you.
I wish I.
Gentleman yield back his time. We now entertain a unanimous consent request to allow Mr. Inslee to sit at the subcommittee level without objection, so ordered, and he will be our final questioner before we go into the markup. So I would yield now 5 minutes to the gentleman from Washington State, Mr. Inslee.
Thank you, Mr. Chair. Thank you for your courtesy. Let me participate. I appreciate it. These are very important things. I want to thank all the panel for being here. These issues and the constellation of issues this represent, with all the problems we've got in the world, from Libya to for gas prices, this one I hear more about. I mean, not necessarily more than some of those others, but a lot about. And I've almost come to think that when people in my district think about life, liberty, and the pursuit of happiness, they think about free access to the internet as either life or liberty or pursuit of happiness, or maybe all three of them. And they really do perceive a threat to that, because certain business plans could result in the loss of their decision making about what they look at on the internet, and losing that ability and that going to some commercial entity instead, or imposing costs on them that aren't necessarily in their benefit. So it is a huge issue in my district. People are very, very concerned about it, and I am as well. And I don't believe the FCC actually went farther enough to guard against the life of that life, liberty, or pursuit of happiness interest, in part because it didn't deal with the wireless spectrum, which is the future. We're really talking about the past or the present here in wired, but wireless is the future, and the fact that we haven't considered protections on that is very disturbing to me. So I just have a couple questions. First off, for Mr. Cicconi, do you think that consumers are the ones that ought to have final say in deciding what content and services they have when they access the internet? And in what ways, if any, does the present order restrict those consumers, if any?
I think by and large, I think we're, the objective of our business is to provide that very access, and it's not our position or policy to hinder it in any way. As I've said before, I don't think we've done that in any way, and I think it's in the interest of our business to make it as broadly available as possible.
And do you think that the FCC's present net neutrality order restricts access of consumers to access they would want in any way?
I don't think so, Mr. Inslee. I'm not sure I'm getting the import of your question. There are provisions in the rule that provide for and allow for reasonable network management, which, I mean, there are certain things you have to do to make sure a network runs properly, and then on shared networks such as cable or wireless, your objective is to ensure the most access for the most people at any given time. And so there could be policies or terms and conditions on the service that are related to the ability to management of that network that could impede that. But I think the Commission has recognized that, and I don't think there's any disagreement that we have with the Commission about the importance of that.
Thank you. Mr. Turner, I want to talk, if I can, about previous frameworks. Isn't it true that non-discrimination really was the agreed upon rule of the game, if you can call it that, during the past few decades, and including during much of this explosive growth due to the internet? And AT&T really agreed to that principle in net neutrality in FCC merger approvals. If that's the truth, and I think it is, what is the reason that the American people should be asked to abide by jettisoning that framework?
Well, I don't think they should, and you raise a great point. I always turn back to the 96 Act because that's the governing law here. The focus of the Act was keeping internet companies like AOL, CompuServe, Prodigy viable. They were dependent on the infrastructure. We had great ISP choice there. We had any consumer could choose dozens of ISPs. And there was no way I think Congress would have said the FCC should be allowed to invent words like inextricably intertwined to basically take away that choice. I don't think Congress would have wanted in 96 to look out at the world of ISP choice and say, 15 years later, I only want consumers to have choice of 2, and I don't want them to be able to choose the content that they would like to access on the internet. I wish this body could return to first principles, return to the principle of non-discrimination. The FCC may not have done it the right way. Let's talk about the right way to do it.
Thank you.
Gentleman concludes his questioning and returns his time. We have concluded now the hearing phase today, actually the hearing today, our second hearing on this topic. We have a document that's been shared with the minority. We'll put in the record, National Broadband Plan for Our Future. This is from Solicitor General Seth P. Waxman, former Solicitor General, counsel for the United States Telecom Association. I assume not necessarily a relative of the former Chairman Waxman. And in it, he makes the case that the internet was never regulated at the retail level. Without objection, this will be entered in the record. And with that, the subcommittee will be adjourned. Thank you again for testifying. It's been most helpful to our process. For our committee members who are watching, listening, or somewhere out there in telecommunication land, we will reconvene as the subcommittee and for purposes of the markup on this legislation at, let's say, 3:30. So 15 minutes, we will reconvene for the markup. We stand adjourned as the Subcommittee on Communications. The committee will come to order. The chair recognizes himself for an opening statement. As I stated in my letter to the ranking member yesterday, and in my opening statement today, H.J. Res. 37 is a resolution introduced under the powers vested in all members pursuant to the Congressional Review Act. Congress enacted the CRA in 1996 on a bipartisan basis as part of the Small Business Regulatory Enforcement Fairness Act. The ranking member's letter of March 7, 2011 confirms the opinions of the House parliamentarian and the committee's general counsel by correctly noting that no amendments to a CRA resolution are in order in the House. The bipartisan co-sponsors of the resolution and I chose to follow the procedure set forth in the CRA to ensure that the matter was brought to a prompt and guaranteed vote in the United States Senate. I'm far from reticent about marking up a regular HR bill, but doing so would obviously eliminate our ability to use the CRA process to more immediately repeal the FCC's attempt to regulate the Internet before it does lasting damage to the Internet itself. However, in, quote, remaining consistent with the traditions of open debate that are a hallmark of our committee, as the ranking member has recommended, we will follow regular order during the subcommittee's markup of H.J. Res. 37. A vote against the resolution is nothing more than a vote to allow the FCC to reclassify broadband under Title II once the agency loses the appeal of this order in court. More than 300 members from both sides of the aisle have opposed such reclassification. Moreover, 58 Democrats voted with us in 2006 to oppose network neutrality. Some of those Democrats are still on the committee. Some are still on this subcommittee. And that was not even a vote against a Title II versus Title I approach. That was a vote against imposing network neutrality rules altogether. Some claim the resolution causes uncertainty. We've heard that today. It does just the opposite. Large and small businesses alike have thrived on an Internet free of government regulation. That's the status quo. It is the FCC's order that threatens to break the Internet as we know it, not the resolution. The resolution is simply a narrowly tailored vehicle to eliminate rules regulating the Internet that the FCC did not have authority to impose. Of far greater concern should be the order. To say the order creates certainty is absurd. The only uncertainty the order even partially resolves is the uncertainty the FCC itself created by threatening reclassification. And the agency has not even closed the Title II proceeding. It's left it open. Supporting the resolution of disapproval will also avoid the collateral damage to the FCC's authority that would come when the agency loses the appeal in court. Remember, their rule is being challenged by Verizon and Metro PCS in court. Some carriers have decided that bad was better than worse, and they were large enough to absorb the hit from the rules. That's a far cry from the story the FCC is telling, that industry supports the order and it's good for the economy. And what of the smaller providers, like Mr. DeReggi, who testified today? He does not have the resources either to absorb the hit or send a team of lawyers to camp out daily at the FCC. And as Mrs. Kovacs pointed out, the rules create a regulatory weapon to shift costs from web companies to broadband providers, harming both the core and the edge of the Internet in the process. For those reasons, I urge my colleagues to support the resolution. I now recognize my friend from California, the ranking member of the subcommittee, Mrs. Eshoo, for her opening statement.
Thank you, Mr. Chairman. What's obvious on my part is that I don't agree with this, to put it mildly. Very respectfully, I really believe that it's a waste of time. We have heard from witnesses at both today's hearing and at other times on this whole issue of companies flourishing in open and accessible Internet. We've heard economists, we've had consumer organizations. Your witness from the consumer front today, you heard what that person said. There are over 1 million people that weighed in at the FCC saying we want the Internet kept open and accessible. There are hundreds of organizations that have weighed in. And it seems to me that there's a legislative tin ear here. That's why I really don't think this is necessary. But the majority believes that. Even AT&T was here today and said that they thought that this was a light touch in terms of a regulatory framework at the FCC. So small, medium, and large, broadband providers, small innovative businesses, consumer organizations, you name it, they support what I just described. So that's why I think this is a waste of time. But I also think it's going to do damage. We didn't raise the issue of uncertainty ourselves. It's what business people have told us. All markets want certainty. And to upset that apple cart, I think, is fooling around with something that we shouldn't be fooling with. And uncertainty in the broadband ecosystem, as well as in any other kind of system, is the last thing a fragile economy needs now. There are a lot of people that give lip service to jobs. There is no sector of our national economy that has produced more jobs than what's related to the internet. So today, you're tinkering with something that, that I think is legislatively uncalled for on the one hand, but also, I think, is dangerous, and it's not necessary. There are hundreds of billions of dollars that have been created in our economy. I think simple rules of the road for the American people, if you really and truly understand what an open and free internet is, you would stand on the side of consumers that want to keep it that way, that consumers be in the driver's seat. That's my position, and I believe the position of an overwhelming number of people in the country. So I think it's regrettable that the CRA is being taken up. I think that there's no heed being paid to the organizations, the businesses, the consumer organizations, the high technology associations, and the companies that comprise those associations. You're just throwing that overboard. So I think CRA is going to stand for can't resolve anything rather than Congressional Review Act. And I think that it's unnecessary. And again, I said earlier today that there's like this virus that's infected the majority in the Congress. God forbid that any agency move forward either to carry out the laws that the Congress has charged them with or that we interact with them and set up rules that are going to protect the consumers and businesses in our country. So I am against this. I don't think it's necessary at all. In fact, I think it's damaging. Thank you.
Gentlelady's time's expired. The chair reminds members that pursuant to the committee rules, all members' opening statements will be made part of the record. Are there further opening statements? Chair, Mr. Terry.
Thank you, Mr. Chairman. And we on this side want a fair and open, untouched internet, untouched by government hands. Certainly we want the consumers to be empowered, which when government starts regulating, consumers lose that power. We believe that an agency's power to regulate should be specifically allowed by Congress, and whatever power is authorized by Congress to an agency should be limited. Neither is true with the FCC and this net neutrality rule. It was neither authorized or Congress did not specifically allow the FCC to start regulating the internet, nor do they have any limitations on its powers. And as we found out from this hearing and one with the FCC, there are many businesses that rely on the internet that are now hoping that the FCC rules in their favor. For example, one business wants to make sure that there are no tiered service by providers. Tiered meaning the more power you use or the more speed, the more megabits you get, that you will pay more. They want a flat, simple system because that advantage is theirs. So instead of consumers making that choice, you have the FCC. That's why we're doing this. It isn't the flu. We're doing what the Constitution states we should be doing.
Gentleman's time's expired. Chair recognizes the ranking member of the full committee, Mr. Waxman, for 4.
Thank you, Mr. Chairman. Today we're considering a terrible bill under an even worse process. The legislation we're considering would allow phone and cable companies to control what websites Americans can visit and what applications they can run. This is a fundamentally bad idea. It's opposed by high-tech industry, consumer groups, religious groups, and labor unions. Even the big phone and cable companies that might stand to benefit the most from this legislation are not asking Congress to act. American businesses want to see an end to the debate on how to preserve a free and open internet. They're looking for certainty and clear rules that will allow them to focus on their business plans rather than their Washington offices. At the hearing we just concluded, we heard from an economist, a technology entrepreneur, a major broadband provider, that the FCC's rules are reasonable and balanced. Although some wish the FCC had gone further, the FCC acted to provide basic rules that companies can follow, investors can rely on, and consumers can turn to for protection. Republicans couldn't get a single major broadband provider to testify today in opposition to the rules or in support of their legislation. Yet our Republican colleagues insist that we move forward with a resolution to invalidate the FCC's rules. That will create more uncertainty in the broadband marketplace, and it will stifle innovation and growth. As bad as the substance is, the process is even worse. The Republican majority is using the Congressional Review Act to strike down the FCC's rules. This extraordinary process gives the majority the ability to deny us a vote on amendments. That is fundamentally unfair. It means we'll have no opportunity to propose changes that might improve this legislation. Instead of an open and deliberative process, this bill is being rammed through under procedures that take away the minority's most basic rights. If this legislation passes, consumers will not have a right to know whether their internet connections are as fast as advertised. They will not have a right to know how their provider is managing their data or charging them for certain services. Yet we cannot even offer an amendment to restore these basic consumer protections. This resolution also leaves deficiencies in other important areas, including public safety, cybersecurity, copyright protection, and protecting children online. But under this process, members may have no opportunity to fix them. The majority does not need to use the CRA to block the implementation of the FCC's rules. If they feel that the authority over broadband should be more specifically delineated by Congress, they could bring before the committee a piece of legislation designed to do just that. We face no pressing time constraint that justify denying the minority the right to amend the bill. The FCC's order has yet to be published in the Federal Register, will not take effect for months. If the Senate considers this measure, it will not do so until Federal Register publication occurs. So it's unclear why we are rushing to use this extraordinary process over the unanimous objection of Democratic members. I yield back my time.
Mr. Chairman. Time's expired. I recognize the gentleman from Texas, Mr. Barton.
Is it in order to give an opening statement or to strike the requisite number of words?
It is in order to give an opening statement for 1 minute.
1 minute.
The ranking member and the chair, the ranking member of the subcommittee, the full committee, and rankers each get 4, and then everybody else gets 1.
Okay. Then I would seek recognition for 1 minute.
So you are so recognized.
Thank you. I could not more fundamentally disagree with my good friend from California in what he just said. If he's right, then the only way to protect people is for the government to do it. On the other hand, if Chairman Walden and all the co-sponsors of this legislation are right, open, transparent markets in a deregulated environment where consumers can choose and providers can choose is the much more cost-effective way to go. That's the way we've been so-called regulating the internet for the last 15 years, 16 years. I think it's worked extremely well. This bill, which I'm proud to be a co-sponsor of, all it does is, one, reestablish congressional authority over the FCC, and two, make it explicitly clear that we believe in markets, we believe in openness, and we believe in transparency, and we trust consumers and providers in a fair, open marketplace to determine the balance of how the internet shall be used. With that, I yield back.
Gentleman yield back his time. Recognize the gentleman from Massachusetts, Mr. Markey, for 1 minute.
Thank you, Mr. Chairman, very much. There is no reason to rush here. The Senate is not going to take this up until the summer. We're going to change something which the CTIA can live with, the NCTA can live with, the major carriers can live with, the competitors can live with, and as yet there has been no problem that has been identified in the marketplace. If we are going to act, it seems to me, it should be after something is identified. We've been assured by the witnesses today that thus far none have been identified. And so if we act this way, then we might as well just turn ourselves into a regulatory agency. I think if you can identify a serious problem as it is actually emerging, then we should move forward. But right now, consumers need it. Big companies support it. Entrepreneurs in our economy rely upon it. But the majority is trying to repeal it. It makes no sense. And now we're going to send it over to the Senate, where it'll just linger for 3, 4, 5 months before they even take it up. That's disrespectful to this committee's tradition in telecommunications, where we finish a process in its totality and then send it over to the Senate for their consideration.
Gentleman's time's expired. Sounds a lot like the FCC's decision not to do market power analysis before they act. Chairman recognizes the gentleman from Ohio, Mr. Latta.
Well, thank you, Mr. Chairman. I am a co-sponsor of and fully support the resolution before the committee because it's Congress's prerogative to stop agency rules that will harm our nation's economy. Furthermore, in the case of the net neutrality ruling, I do not believe that the FCC had either the authority or the rationale to issue these controversial rules just a few days before Christmas of last year. Regulations stifle small business, whether they are from the EPA, Obamacare, or the FCC, and I hear these stories every day from the businesses across my district in northern Ohio. The internet is the culmination of years of private enterprise that has thrived without regulation. It has experienced explosive growth in the last 20 years, and it continues to do so. The FCC's net neutrality decision brings additional government not just into people's lives, but also into our free market economy, attempting to provide a solution to a problem that doesn't exist. The additional government regulation will only result in stifling economic growth that our nation so desperately needs. And with that, Mr. Chairman, I yield back.
Gentleman yields back the balance of his time. Who else seeks recognition? The gentlewoman from California, Ms. Matsui.
Thank you, Mr. Chairman. Mr. Chairman, I am strongly opposed to this resolution. Without proper vetting of this resolution, I fear this resolution is loaded with unintended consequences that frankly are not good for broadband providers, small business owners and entrepreneurs, innovators, and most importantly, job creation. That being said, I strongly support the FCC's open internet order because it lays the foundation to create market certainty that protects consumers, spurs innovation and investment, and creates jobs in our economy. I believe this attempt to repeal the open internet order is irresponsible and will send mixed signals to investors that will stifle innovation and discourage job growth in broadband technology sectors of our economy. Mr. Chairman, I strongly urge a no vote on this resolution. I yield back the balance of my time.
Thank the gentlelady. Any other people seeking recognition on the Republican side? If not, we'll go down here. And I believe Mr. Rush was here before Mr. Pallone. So, Mr. Rush, for 1 minute.
Thank you, Mr. Chairman. Here we go again. We're consuming valuable time that could and should be spent considering, discussing, and debating what the witnesses told us earlier today before we recess. With no disrespect meant to the aforementioned witnesses, we should be dealing with more pressing matters. For one, I'm surprised with the 10th anniversary of 9/11 and the 6th anniversary of Hurricane Katrina and Rita, a mere 6 months or so away, that we've not gotten to the challenging issues of clearing or finding spectrum for public safety and first responders, and how to go about funding the build-out of an interoperable public safety network to protect our homeland. What we're doing, Mr. Chairman, sets a very dangerous precedent. This subcommittee is taking an extremely rare action today by proposing to nullify the FCC's open internet rules by using the Congressional Review Act vehicle, which has been used far more by the Senate than in this chamber. Coupled with that, the majority has had the audacity to say that members will not be recognized for the purposes of offering an amendment. Mr. Chairman, I intend to vote against this measure, and I encourage all of my colleagues to do the same.
Thank the gentleman for his comments. I would say that it is the statute and the way it is constructed that precludes amendments to it. Mr. Pallone, I apologize. I'm reminded in a markup we go by seniority, so I recognize the gentleman from New Jersey.
I have no problem. I came later, so thank you, Mr. Chairman. I don't want to take up too much time, but I did want to put on record my opposition to today's proceedings. I know that my Republican colleagues will say that H.J. Res. 37 is a necessity that must be put onto a fast-track procedure, but I believe you're accomplishing nothing more here today than stifling this subcommittee's ability to debate and vote on amendments, both important prerogatives. Now, I also don't understand why my Republican colleagues want to continue debate on this issue. I took a hiatus from this subcommittee last Congress, but now that I'm back, I hear a lot more from advocates, organizations, and companies that are affected by the jurisdiction of this subcommittee. And I want to make one thing clear. Not one meeting that I've had in my district has been about net neutrality. Not one advocate, organization, or company has urged me to pursue overturning the FCC order. But those same stakeholders have a lot of concerns. They're concerned about broadband access. They're concerned about spectrum reform and wireless capacity. They're concerned about the Universal Service Fund reform. So here we are. It's 10 weeks and 0 jobs bills later. And today I just can't understand why this subcommittee isn't meeting on these important issues which need to be addressed to promote innovation and create jobs. Thank you, Mr. Chairman.
Gentleman's time's expired. I'd remind the gentleman we had planned to do this markup last week, and at the encouragement of the majority, we held a hearing today and postponed the markup. I would now recognize anyone else seeking resignation.
Mr. Chairman, point of order. I don't think you need to make a running commentary. We could have started this markup much earlier, but we had the hearing, and all the members wanted to ask questions. It looks like your members don't want to make opening statements. Some of ours do. Let's proceed on regular order.
Anyone else seeking recognition? Seeing no one, Chair is now prepared to call up the resolution. Before I do so, I want to make clear how the subcommittee will operate in considering the legislation. The Congressional Review Act is obviously an extraordinary procedural device. Although the consideration of a joint resolution of disapproval in the House is done largely under regular order, the CRA provides for certain expedited procedures in the Senate. These procedures immunize the resolution from the filibuster and subject it to a simple majority vote after limited debate. For our purposes today, the statute specifies the precise language that must be used in a joint resolution of disapproval. As a result, no or virtually no amendments to the resolution are in order. Any amendments would be at odds with the fundamental purpose of the resolution, which is to simply disapprove an agency action through the statutorily prescribed language that will soon be before us. Such amendments will therefore be non-germane. We have thoroughly vetted this issue with the House parliamentarian. In order to ensure that members would have ample time to debate the joint resolution before us, I've offered to the minority a time agreement under which both the minority and majority would control debate time on the merits of the resolution. Unfortunately, the offer's been rejected. So for the budding parliamentarians out there, stay tuned for a lesson. Chairman now calls up H.J. Res. 37 and asks the clerk to report.
H.J. Res. 37, joint resolution disapproving the rules submitted by the Federal Communications Commission with respect to regulating the Internet and broadband industry practices. Resolved by the Senate and House of Representatives of the United States of America and Congress assembled, that Congress disapproves the rules submitted by the Federal Communications Commission relating to the matter of preserving the open Internet and broadband industry practices. Report and Order FCC 10-201 adopted by the Commission on December 21st, 2010, and such rules shall have no force or effect.
Is there any discussion on the resolution?
Mr. Chairman?
Gentleman from Michigan.
Mr. Chairman,
For what purpose the gentleman from Michigan seek recognition?
strike the requisite number of words.
Gentleman's recognized.
Mr. Chairman, this is an exercise in the most exquisite frustration. The proposal is not going to be considered in the Senate. It may or may not pass the House. It probably won't accomplish what we want to do. On top of that, it is almost sure that the Senate will be moving forward on other components of public policy in the area of broadcasting and in the area of spectrum use. So they're moving, as I understand it, on matters both involving spectrum and other things at this particular time. So we're ceding then much of our legislative responsibilities to the Senate. We're engaging in disapproving of something that the Federal Communications Commission is doing, which is probably not good sense. And I don't happen to support it, as I think you don't happen to support it. But I would just observe that the proper place for this matter then to be reviewed is in the courts. And the action of the FCC is going to be tied in the courts for a goodly while and never ever reach any semblance of reality. So I think that this is a bad way to proceed. But unfortunately, Mr. Chairman, and I say this respectfully, it appears that this is also a bad way to proceed because members are not being permitted to offer amendments and to have these things discussed in a proper and full and thoughtful way inside this body. And I say this again with great respect for you. But this is rather inconsistent with the way that this committee has its history of running. We've always tried to allow the members to have the fullest opportunity to say what they had to say, and a full opportunity for everybody, far right, far left, and in between, to say what it was they wanted to say in the belief that this resulted in better legislation. So the end result here is that we're having a fine exercise in frustration. We're having a piece of legislation come out that is not going to go anywhere or do anything. The Senate is going to seize its opportunity and do things and look like a legislative body, which is a great curiosity. And the end result of the whole business is that this is probably a great dissipation of time that might otherwise be better used for something else. Having said that, I do think that we ought to be able to offer amendments to this. I don't happen to have any. I happen to strongly oppose what the FCC is doing. I happen to think that the courts are going to hit them on the head and say, fellas, you were dead wrong. And the end result is going to be that we're having a fine time being together at 4 o'clock on this afternoon, but we're not going to accomplish a whole lot. And I do thank you for your kindness in recognizing me.
Gentleman yield back his time. Gentleman yields back his time. For what purpose does the gentlelady from California seek recognition?
Yeah, Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Gentleman from Nebraska reserves a point of order. Is there a specific number on your amendment? Yeah.
Amendment to H.J. Res. 37, offered by Ms. Eshoo.
Mr. Chairman, this is, oh, he has to read it. You can I ask for unanimous consent and consider the amendment read.
Without objection. Gentlelady's recognized. The gentleman from Nebraska continues to recognize. Gentlelady's recognized to speak on her amendment.
Thank you, Mr. Chairman. This is really a very simple amendment. If the FCC is in consultation with the Secretary of Homeland Security and determines that this rule will undermine the needs of law enforcement, homeland security, public safety, or national security personnel, the resolution should not be acted on. So I'm offering this amendment because I'm concerned about the unintended consequences that the resolution would create. The FCC's open internet rules are intended to ensure that broadband providers can meet the needs of public safety. We haven't spent very much time talking about public safety during today's considerations and not a great deal when the FCC was here before us. Under what I believe are the ambiguities created by the CRA, it's unclear whether the FCC can adopt new rules that would provide this protection. So I'd like to just ask the council a few questions. The CRA states that any disapproved rule, quote, may not be reissued in substantially the same form, and a new rule that is substantially the same as such a rule may not be issued unless new laws are enacted by Congress. So again, I'm troubled by the uncertainties that would be created by this language. Can you explain to me what the term substantially the same means? And does it mean that the FCC cannot adopt open internet rules requiring disclosure, no blocking, no unreasonable discrimination, but that it can adopt other types of rules?
So, Ms. Eshoo, these rules would be nullified. If the FCC so chose, it could try and adopt different regulations. If someone thought that those regulations were substantially similar, they could file an appeal in court and argue that the new rules were still disapproved under the resolution because they were substantially similar to the rules that would have been disapproved.
If the resolution is enacted, do you believe that the FCC retains the jurisdiction and the authority over broadband internet access providers to resolve complaints alleging discriminatory network practices?
The FCC believes it does. That is a matter before the court in the Verizon.
But if the resolution is enacted, do you believe that you, here, as our lawyer, I'm not asking you what the FCC people think. I'm asking you what would happen relative to the enactment of this resolution.
So if you're asking my opinion, I do not believe the FCC has the authority to regulate the internet.
None whatsoever?
That's correct. These rules are not authorized. In my opinion, these rules are not authorized.
Could the FCC implement recommendations contained in the National Broadband Plan regarding cybersecurity?
The FCC believes they can, yes.
I'm asking our attorney here.
I'm sorry, so what are the rules?
I'm asking you.
Yes, so what rules?
Could the FCC, in your view, implement recommendations contained in the National Broadband Plan regarding cybersecurity?
Yes.
At the request of a broadband provider, could the Commission issue a declaratory ruling that would give that provider the flexibility needed to prioritize certain public safety-related traffic?
I'm sorry, could the FCC allow prioritization?
Mm-hmm.
Prioritization can occur under current law.
So anything relative to public safety is not knocked out by the CRA?
That's correct. Carriers are allowed to prioritize traffic under current law in the absence of...
Does the FCC have, in your view, under this resolution that's being considered, have the jurisdiction to carry out the public safety issues that are facing the nation?
Yes, their ability to carry out public safety issues are not related to the network neutrality order.
In no way, shape, or form?
That's correct.
Thank you. I'd be glad to.
The fact that the FCC could not revisit the issue of the freedom for the internet rules is, I think, a major reason why a lot of the stakeholders have said to us, just leave it alone. There are more important things for this committee to do. We've got public safety. You can leave it to the FCC, but perhaps Congress should play a role in it, and I think we ultimately will have to. We should be doing something in other areas as well, working together on a bipartisan basis. If this proposal is carried, not only the rules...
time has
I
expired.
ask unanimous consent for another 30 seconds.
For another 30 seconds without objection.
If this rule is carried, then the FCC's rules are negated, but the FCC's ability to deal with this issue is also canceled. And so I think that it leaves things in an uncertain position, which is why I think we ought to reject this rule and allow the rules to stay in effect, or legislate to change them, not this way.
Does the gentleman from Nebraska insist on his point of order?
Yes, I insist.
The gentleman insists on his point of order. The chair is prepared to rule that the amendment is not in order.
Mr. Chairman, I'd like to speak on the point of order.
Gentleman's recognized briefly to speak on the point of order.
Mr. Chairman, I know that if you use this procedure of the Congressional Review Act, you will rule that it's not germane. But I just want to re-emphasize and underscore that traditionally this committee used germaneness objections because the amendment wasn't relevant to the subject matter or the amendment was outside the scope of the committee's jurisdiction. Neither of those circumstances apply to this amendment and or the other amendments that we'll be proposing to offer today. It's indisputably within the committee's jurisdiction to review and develop communications policy, and the amendments we're proposing today focus squarely on the subject of the FCC Open Internet Rule. The only basis for a point of order is that an amendment does not conform to the Congressional Review Act. Now, that act may give you a chance at the Senate to stop them from offering amendments as well. It's an expedited procedure that they can use to stifle debate, as we are now having stifling debate on proposals. And I would hope that if members don't raise points of order, we could go ahead and consider and debate and vote on the substance of the amendments. It's time we look at other issues and have them fully before us. And so I make that point to you for your consideration.
Appreciate the gentleman's discussion. I now recognize the gentleman from Nebraska on his point of order.
I insist on the point of order. The amendment is not germane to the joint resolution. The joint resolution contains statutorily prescribed language under the Congressional Review Act. The amendment seeks to change that language in a manner that would alter it from its privileged form and would violate the fundamental purpose of the joint resolution. It is therefore non-germane.
Chairman's prepared to rule that the amendment is not germane. And the gentleman, the amendment is not germane to the joint resolution, and the joint resolution, hold on just a second, sorry. Chair finds the amendment seeks to amend the joint resolution before us in a way that will fundamentally alter the prescribed form of the such joint resolutions under the Congressional Review Act. The gentleman is therefore correct. The amendment is not germane. The amendment is not in order. Once again, as both sides have agreed that under this act, amendments are not germane and not in order. I have agreed with the former chairman to allow discussion on the amendments up to a certain point. For what purpose does the gentleman from Massachusetts seek recognition?
I have an amendment at the desk.
Clerk will report the amendment.
Amendment to H.J. Res. 37, offered by Mr. Markey.
I reserve a point of order, Mr.
Gentleman
Chairman.
from Nebraska reserves point of order. Gentleman from Massachusetts recognized on his amendment.
Thank you, Mr. Chairman, very much. This is, of course, a momentous occasion for this committee. This motion of disapproval has been used only once in 15 years. So we all know that we're dealing with a very solemn subject here in this room. We all know as well that it is important for us as the Committee of Jurisdiction not to invoke the law of unintended consequences in an area so sensitive to the growth of the American economy. This is really an historic moment for this committee. So what my amendment would do is to specify that if Congress disapproves the open internet rules adopted by the FCC last December, that nothing in the joint resolution will undermine the authority of the Commission to protect internet users, including authority with respect to emergency communications, child pornography, online privacy, spam, and parental controls. We just have to ensure that we clarify this before we act. And why is that? Because obviously a resolution of disapproval is a very blunt instrument to be used in such a very sensitive area. Under the open internet rules adopted by the FCC, exceptions were created for broadband internet access service providers to engage in reasonable network management, including prioritizing emergency communications, protecting networks against spam, blocking transfers of unlawful content such as child pornography, and accommodating end-user choices regarding parental controls our security capabilities, such as to protect private information. I think we can all on the committee agree on these issues, but we have to make sure that we preserve the authority at the FCC as we act by adding the legislation, by adding the language that will accomplish that goal. Under the ambiguities created by the Congressional Review Act, it is unclear whether the FCC can adopt new rules that maintain these important exceptions to meet the needs of public safety, protection of children, and shielding the networks from spam. Mr. Chairman, I believe few people in this room would disagree that a broadband network provider must be able to manage the traffic to promote these very important features of an open internet. If the resolution of disapproval becomes law, forbidding the FCC from reissuing rules in substantially the same form, I am very concerned that the FCC will not be able to offer such flexibility to broadband providers promoting the public safety, dealing with child pornography, protecting consumers against fraud and unfair and deceptive practices. Therefore, I believe that my amendment is critical in providing some clarity so that broadband providers will be able to continue to ensure the integrity of their networks, and I hope that the members in the majority can find a way of allowing us to add this codicil in, so that as the resolution of disapproval moves forward, that we are able to ensure that those protections will be there for American families, and that those protections can be maintained. And with that, I yield back the balance of my time.
Gentleman yields back the balance of his time. As the council has testified, this does not have does not affect the FCC's ability to regulate the very things that you've discussed. And as the members of the Democrat side, in your letter to me of March 7th, you admitted that this law that we're operating under precludes amendments. So I just want to state that again. Let's understand what's happening here.
Mr. Chairman, I insist
Nebraska.
on the point of order.
Gentleman insists on his point of order. The chair is prepared to rule that the amendment is not germane to the joint resolution. The joint resolution contains statutory prescribed language under the Congressional Review Act. This amendment seeks to change that language in a manner that would alter it from its privileged form and would violate the fundamental purpose of the joint resolution. It is therefore non-germane. What purposes, gentlemen from Pennsylvania, seek recognition?
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will read the amendment. Report the amendment.
Amendment to H.J. Res. 37, offered by Mr. Doyle.
I reserve a point of order.
Gentleman from Nebraska reserves a point of order. Mr. Doyle, would you like to speak on your amendment?
Yes, thank you, Mr. Chairman. Mr. Chairman, my amendment simply tries to ensure that even if the resolution of disapproval we are considering today is enacted into law, broadband providers will not be able to block or interfere with consumers' access to lawful websites at will. That freedom is one of the most essential aspects of Internet openness. It's what turned the Internet into the economic engine it is today. But reading the testimony today, some broadband providers want the right to block what you get to see. The no-blocking principle has been broadly accepted since it was included in the FCC's 2005 Internet Policy Statement. It has garnered the support from both Democratic and Republican FCC commissioners. Indeed, as early as 2004, then FCC Chairman Michael Powell gave a speech in which he outlined 4 net freedoms. The first freedom was that consumers should have access to their choice of legal content. Chairman Powell stated at the time that consumers have come to expect to be able to go where they want on high-speed connections, and those who have migrated from dial-up would presumably object to paying a premium for broadband if certain content were blocked. In addition to being reaffirmed by the Internet Policy Statement, the no-blocking principle was incorporated into the Communications Opportunity Promotion and Enhancement Act of 2006, introduced by then-Chairman Barton. All of my Republican colleagues at the time, who are still here, voted in favor of that bill. Mr. Chairman, I regret that we're not able to consider this amendment that reflects such fundamental principles of the Internet that consumers have come to expect. The resolution that we are considering today, if ever enacted, will strip the Commission of its authority to police the most egregious of conducts on the part of broadband providers, such as blocking consumers' access to lawful websites of their choice. The Commission has done so before, rightly, when an ISP called Madison River tried to block Vonage phone calls. But if Congress steps in and tells the FCC that it has no role to prevent it, we will be giving broadband providers a green light to block from consumers any application, content, and services they choose to block. Now, Mr. Chairman, I am not saying that all providers will do this, but certainly some will. One witness today said in his testimony that he wanted to block legal web traffic from his consumers who want it. The incentives for mischief are there, and companies are profit-making enterprises, not protectors of free speech. I want to ask the Council two questions so that I can have a better understanding of the practical impact of this legislation. So I'm just going to use Verizon as an example since they sued the FCC first. Tell me, Council, what would happen if Verizon decides to block certain political websites sponsored by the Tea Party or MoveOn.org because they decided those sites are too controversial and they want to limit access so as not to offend their consumers? If the CRA became law, could the FCC act to prevent such blocking?
So Mr. Dole, I'm trying to be fair to the FCC. I can give both my opinion and what I think the FCC argues. Ms. Eshoo wanted my opinion. Do you want my opinion? Or
I'm asking you, if CRA becomes law, in your opinion, could the FCC prevent that blocking?
They could not adopt a substantially similar rule. So the FCC believes they could, and they could try again, and as long as it was
but
not...
you believe they could?
I believe they don't have the authority at all, which is why they can't even do it today, regardless of the net neutrality order.
But is it your statement that if CRA were to become law, that you do not believe FCC would have the authority to block Verizon or to stop Verizon from blocking?
No, sir, that's not my view. It would take a court to determine that. A court would have to decide whether the new regulations were substantially similar to the ones that were disapproved.
Well, I understand what you're saying, but what legal authority, under what legal authority would the FCC be able to prevent blocking if the CRA passed? What would be their authority to do that?
To be fair, this is where I disagree with the FCC. The FCC believes it has authority under Section 706, Title II. We're not eliminating that authority. Now, a court may agree with me eventually that those sections don't give them the authority, but if the FCC wins in court, they can adopt other regulations under those sections so long as they are not substantially similar.
But what the CRA intends to do right now is that's covered under this. I mean, blocking would be covered under that.
These particular rules on blocking, that is correct. But if the FCC does have authority under Section 706...
So if CRA were to become law, they couldn't stop any company from blocking?
No, sir, that's not necessarily correct.
Gentlemen, time has
I see my time's expired. Thank you, Mr. Chairman.
Mr. Chairman?
Just if a gentleman would suspend for a second. This amendment seeks to extend the Commission's authority beyond that provided for in statute. Isn't that correct, Counsel?
That is my opinion. The FCC disagrees, just to be fair.
Got it. Gentleman from
Mr. Chairman, I must insist on the point of order that the amendment is not germane to the joint resolution. The joint resolution contains statutorily prescribed language under the Congressional Review Act. This amendment seeks to change that language in a manner that would alter it from its privileged form and would violate the fundamental purpose of the joint resolution. It is therefore, in my opinion, non-germane.
Chair is prepared to rule on the gentleman's point of order. The Chair finds the amendment seeks to amend the joint resolution before us in a way that will fundamentally alter the prescribed form of such joint resolutions under the Congressional Review Act. The gentleman is therefore correct, and the amendment is not germane, and the amendment is not in order. For what purpose does the gentlewoman from California seek recognition?
I have an amendment at the desk.
I am shocked. Clerk will read the amendment. Report the amendment.
Amendment to H.J. Res. 37, offered by Ms. Matsui.
Mr. Chairman, I reserve a point of order.
The gentleman reserves point of order. The Chair recognizes the gentlewoman from California to speak on her amendment.
Thank you, Mr. Chairman. Mr. Chairman, my amendment simply preserves a portion of the Open Internet rules imposing a transparency requirement on broadband providers so that consumers and developers can make informed choices. The transparency rule is also the least controversial aspect of the rules and overwhelmingly supported by broadband providers, high-tech companies, and consumer groups. In fact, during the hearing we just completed, all 6 of the witnesses, including the 3 majority-picked witnesses, voiced their support for the FCC's 6th principle on transparency. There is simply no reason for a resolution disapproval to throw out a rule that the vast majority of stakeholders finds to be beneficial. Imposing a transparency requirement on broadband providers is common sense. Consumers must have the information necessary to make informed choices regarding the types and use of broadband service they purchase. Transparency also generates trust, which in turn increases consumers' confidence in broadband providers' practices, thereby encouraging greater broadband adoption. A transparency rule will also help third parties like edge providers, high-tech companies, and venture capitalists make informed decisions on when and how to embark upon innovative projects and investments. Through disclosure of necessary technical requirements, new and improved online content, applications, services, and devices will continue to be created. Mr. Chairman, I strongly believe the transparency requirement should be preserved. Yet the resolution being considered today will remove this widely accepted measure to protect consumers and innovators as well. Even worse, due to the ambiguities in the Congressional Review Act, the FCC may be prohibited from ever adopting a transparency requirement regarding a provider's network management, performance, and commercial terms unless Congress acts first. It is unclear how the FCC will be able to address consumer protection issues with respect to broadband providers. We need to consider these unintended consequences. Mr. Chairman, I urge support of my amendment.
Mr. Chairman, I insist on a point of order.
Gentleman insists on his point of order.
That it is not germane, and the joint resolution contains statutorily prescribed language under the Congressional Review Act. This amendment seeks to change that language in a manner that would alter it from its privileged form and would violate the fundamental purpose of the joint resolution. It is therefore my opinion that it is not germane.
The Chair is prepared to rule on the gentleman's point of order. The Chair finds the amendment seeks to amend the joint resolution before us in a way that will fundamentally alter the prescribed form of such joint resolutions under the Congressional Review Act. The gentleman is therefore correct, and the amendment's not germane. The amendment is not in order. Who seeks recognition? Mr. Rush. For what purpose do gentlemen seek recognition?
Mr. Chairman, I have a resolution at the desk.
The clerk will read the amendment. Report the amendment. Oh, which, Mr. Rush?
Amendment number 1.
Amendment number 1. The clerk will report Rush Amendment number 1. Could you describe what this amendment is? It appears we have 2 of them, Mr. Rush.
We have a 13, a 14, and a 64.
Oh, 13, 14, and 64. What's the lucky number?
Uniform consumer protections across wireline and wireless internet access services. Uniform consumer protections across wireline and wireless internet access services.
Do you have a copy of it, Mr. Rush? Perhaps we could share with council. We're not sure we have that one.
That was privacy. 10 providers.
It's the 10 providers amendment. 10 providers.
10 providers amendment. Maybe number 14.
Number 14. Okay, we got it.
Clerk will report the amendment number 14.
Amendment in the nature of a substitute to H.J. Res. 37 offered by Mr. Rush of Illinois.
I reserve a point of order.
Gentleman from Nebraska reserves.
I do reserve a point of order.
Gentleman from Illinois is recognized on his amendment.
Thank you, Mr. Chairman. Mr. Chairman, when Congress debated the issue of net neutrality or the open internet, it never did fully explore, as a matter of policy, how by increasing broadband competition, the marketplace would punish open internet violators who might seek to block, degrade, or discriminate among content, services, applications, and non-harmful devices that connect to their networks. When the FCC adopted its open internet report in order in December 2010, much criticism was leveled at the Commission for not extending equal protection to wireline and wireless internet traffic subscribers. I am particularly concerned, therefore, that these rules favor wireline broadband subscribers, notwithstanding the fact that more and more internet access traffic is being sent and received over wireless devices, smartphones, PC tablets, and across wireless facilities. This will acutely affect minorities and low-income individuals and households. Repeated studies have shown that these demographic groups are more prone to subscribe to wireless broadband access rather than to home or fixed broadband. For example, a Pew Internet and American Life Project survey published last year found that 64% of African Americans and 63% of English-speaking Hispanics access the internet through wireless devices compared to 57% of whites. The amendment I am offering today will require the FCC to modify its open internet reporting order to apply uniform protections to wireline and wireless traffic if it finds that there are fewer than 10 providers of mobile broadband internet access service in an applicable service area. The amendment goes further to establish that the threshold speeds in making the provider number determination are 3 megabytes per second for download speeds and 768 kilobytes per second for upload speeds. Because the amendment does not specify which internet access services are covered, be they DSL, cable modem, fiber optics, mobile broadband, and other high-speed internet access, but rather speaks only to transmission speeds, it is technologically neutral in its effect. This amendment will not only combat the persisting problems of what has been called the digital divide, it will also address and hopefully reverse the creation of an emerging vacuum, which I have referred to as being the device divide. Mr. Chairman, with that, I yield back the balance of my time.
Gentleman yields back his balance of his time.
Mr. Chairman, I insist on my point of order that the amendment is not germane to the joint resolution. The joint resolution contains statutorily prescribed language under the Congressional Review Act. The amendment seeks to change that language in a manner that would alter it from its privileged form and would violate the fundamental purpose of the joint resolution. I believe, therefore, it is non-germane.
Chair is prepared to rule on the gentleman's point of order. The chair finds the amendment seeks to amend the joint resolution before us in a way that would fundamentally alter the prescribed form of such joint resolutions under the Congressional Review Act. The gentleman is therefore correct. The amendment's not germane. The amendment's not in order. Who seeks recognition? Gentleman from Illinois, Mr. Rush. For what purpose do you seek recognition?
Mr. Chairman, I have an amendment at the desk.
Amendment number?
13.
Amendment number 13. Gentleman from the clerk will report the amendment.
Amendment in the nature of a substitute to HJ Res 37 offered by Mr. Rush of Illinois.
Mr. Chairman, I reserve a point of order.
Point of order. Gentleman's recognized on his amendment.
Mr. Chairman, last year, once it became known that an employee of a certain large internet service company had been collecting personal consumer data sent over unsecured wireless networks, the revelation made international news. These practices and the facts surrounding these events became the subject of an investigation by the Federal Trade Commission's Bureau of Consumer Protection. Privacy data authorities around the globe and some prominent lawmakers and public officials here in the U.S. were stunned when the FCC ended its inquiry into the matter. Following the FCC's decision to close this investigation, speculation abounded that the FCC, which is another cop on the privacy beat, could have been looking into the matter. As a matter of law, the FCC nor the FTC can neither confirm nor deny what investigations or enforcement action it is contemplating taking. This second amendment, Mr. Chairman, which I am offering today, will clear up the possible confusion as to whether the FCC could continue to undertake investigations of alleged privacy violations committed by communications network providers. Recently, I introduced H.R. 611, the Best Practices Act. As one of the leading proponents in the U.S. Congress of passing comprehensive federal consumer privacy legislation, I know personally that consumers do not care less about where one agency's authority to enforce privacy rules and laws ends and where another protective agency's authority begins. They just want to be assured that their personal information remains protected. The Republican resolution would throw all of this into question without voting upon and approving my amendment. And with that, Mr. Chairman, I ask that my amendment be approved, and I yield back the balance of my time.
Gentleman yields back the balance of his time. Gentleman from Nebraska.
Thank you, Mr. Chairman. I insist on a point of order that the amendment is not germane to the joint resolution. The joint resolution contains statutorily prescribed language under the Congressional Review Act. Mr. Rush's amendment seeks to change that language in a manner that would alter it from its privileged form and would violate the fundamental purpose of the joint resolution. It is therefore non-germane.
Chair is prepared to rule on the gentleman's point of order. The chair finds that the amendment seeks to amend the joint resolution before us in a way that will fundamentally alter the prescribed form of such joint resolutions under the Congressional Review Act. The gentleman is therefore correct, and the amendment's not germane. The amendment is not in order. Chair recognized. For what purpose does the gentleman from Illinois seek recognition?
Mr. Chairman, I have a last amendment. It's entitled Internet Communications Content, Religious, and Nature.
Clerk will report the amendment.
Amendment to H.J. Res. 37, offered by Mr. Rush.
I reserve a point.
Gentleman from Nebraska reserves point of order. The gentleman from Illinois is recognized on his amendment.
Mr. Chairman, last week I reintroduced the Bereaved Consumers Bill of Rights Act, H.R. 900. I initially authored that legislation in the 111th Congress when it was discovered in the summer of 2009 that abominable acts of grave desecration and grossly negligent record-keeping and maintenance had taken place at the Burial Cemetery in Alsop, Illinois, which is located in my district. Thanks to the support of many of the members of this subcommittee in the 111th Congress, we shaped and marked up the bereaved bill, moving it out of full committee to await a House vote. As part of that process, religious organizations that own and operate cemeteries and cemetery funeral home combos weighed in personally with members of Congress, but they also use the internet to make their views known to the public, but also to supporters here on the Hill. If the Republican resolution is marked up and moved out of subcommittee without any call votes on amendments such as this, that I am now attempting to offer, those religious organizations and groups might not have been as effective in making their case for amending the bereaved bill. Accordingly, my amendment will still allow the FCC to propose and adopt rules to protect any internet access broadband provider, regardless of technology, from blocking, degrading, or discriminating against internet communications that are religious in nature. Mr. Chairman, I ask for the support of the committee, and with that, I yield back the balance of my time.
Mr. Chairman.
Gentleman yields back the balance of his time. Gentleman from Nebraska.
I insist on my point of order. The amendment is not germane to the joint resolution. The joint resolution contains statutorily prescribed language under the Congressional Review Act. This amendment seeks to change that language in a manner that would alter it from its privileged form and would violate the fundamental purpose of the joint resolution and therefore is non-germane.
Chair is prepared to rule on gentleman's point of order. Chair finds that this amendment seeks to amend the joint resolution before us in a way that will fundamentally alter the prescribed form of such joint resolutions under the Congressional Review Act. Gentleman is therefore correct, and the amendment's not germane. The amendment is not in order.
Mr. Chairman, I am shocked and shaken by the ruling of the chair.
I understand that. Sorry.
Do we need public safety here?
There's not much more I can say on that point of order. Anyone else seek, Mr. Chair, for what purpose does the gentleman from Pennsylvania seek recognition?
To strike the last word, Mr.
Gentleman's recognized.
And I won't take all the time.
I appreciate that.
I want to get clarification from counsel. Mr. Freed, you're very good, and but I want to get a more complete answer from you. So, in your opinion, not the FCC's, under what specific authority, title, and section could the FCC rely upon to take action against a carrier who blocks a Tea Party website?
So I do not think, let me clarify, I do not think they have that authority. The FCC thinks they have that authority under Section 706 and others.
If CRA would pass, could they use Section 706 to stop blocking?
If 706 gives them that authority, then yes, as long as it's not a substantially similar rule and they have authority elsewhere in the statute, they can adopt other rules that are not substantially similar to the ones that would be disapproved. So earlier, Ms. Matsui had an amendment about a very specific rule already in the order. She is correct that that rule could not be adopted identically, because that certainly would be substantially similar. I would argue they can't adopt it because they don't have authority. But if the FCC is correct that they have authority, they can adopt other rules that are not substantially
So
similar.
you don't believe any title or any section gives them the authority to do that?
The authority that the FCC has cited in the order, I personally do not believe. That may be resolved in the court case if it gets there that Verizon has taken. The issue of the authority is very separate from the issue of the CRA and this order. All the CRA would do is say these specific rules cannot be readopted. If the FCC has authority somewhere else, they can try again.
And that's what I'm asking. Where else in what section or title could they look to?
I don't, but the FCC says Section 706, Title 2.
But they wouldn't be able to use that, right?
No, they could use that authority, just not for the same rules. They'd have to do different rules, and they could cite that authority if the courts say they have that authority.
Yeah. Yeah. Okay, Mr. Chairman, you've been very gracious, and I'll not take up any more of your time.
Gentleman yields back his time. Any further discussion? If not, the question now occurs on favorably reporting the resolution. The clerk will, all those supporting favorably reporting the resolution will vote aye. Aye. We're in training here. All those opposed will vote no.
No.
Roll call vote's been asked for.
I thought the noes had it.
The clerk will call the roll.
Mr. Terry. Mr. Stearns. Mr. Shimkus. Mrs. Bono Mack. Mr. Rogers. Mrs. Blackburn. Mr. Bilbray. Mr. Bass. Mr. Gingrey. Mr. Gingrey votes aye. Mr. Scalise. Mr. Latta. Mr. Latta votes aye. Mr. Guthrie. Mr. Guthrie votes aye. Mr. Kingsinger. Mr. Kingsinger votes aye. Mr. Barton. Mr. Barton votes aye. Mr. Upton. Ms. Eshu. Ms. Eshu votes no. Mr. Markey. Mr. Markey votes no. Mr. Doyle. Mr. Doyle votes no. Ms. Matsui. Ms. Matsui votes no. Mr. Barrow. Mr. Barrow votes no. Mr. Towns. Mr. Pallone. Mr. Rush. Ms. DeGette. Ms. DeGette votes no. Mr. Waxman. Mr. Walden. Mr. Walden votes aye.
Are there members who have not voted? Yes. Mr. Waxman has to leave for an interview, but he wants to vote no first.
Mr. Waxman votes no.
Mr. Towns?
Mr. Towns votes no.
Mr. Shimkus?
Mr. Shimkus votes yes.
Mr. Rogers?
Mr. Rogers votes yes.
Mr. Upton?
Mr. Upton votes yes.
Mr. Scalise?
Mr. Scalise votes yes.
Are there any members not recorded who wish to be recorded? Mr. Stearns?
Mr. Stearns
votes yes. Are there other members not recorded wishing to be recorded? You are not recorded. How would you like to be recorded? Mr. Bilbray votes aye.
Mr. Bilbray votes aye.
Any other members wishing to be recorded? Clerk will report the tally.
Mr. Chairman, 15 aye, 8 nays.
15 ayes and 8 nays. The resolution is approved. Make sure I read the right. Is agreed to, and the resolution is ordered favorably reported. Is there any further business come before the subcommittee? If not, the chair wants to thank all the members and the staff. Subcommittee stands adjourned, subject to the call of the chair.